All right, welcome everybody. I'm going to give people a little bit more time to join before we start getting into the meat of this conversation. So while we're waiting a few minutes, I'm going to go over some housekeeping items. First off, if you're watching us on YouTube or LinkedIn, you can comment. We'll see those comments immediately. We see AC said hello. We see Jeff. And so please, you'll be able to say hello to us. Just let us know you're there. It would be awesome. And then as we go along, please participate, ask questions. We'll see them and we'll try to seed them in the conversation and get them answered. But this is a really, really great opportunity to, we've got Eric here to ask him questions about these two major, and actually we're going to go over three major updates within the last week. So keep that in mind. Please participate. Please ask questions in the comments. Also, another reminder, Lead Generation World, the price goes up on Saturday by $200. So if you're planning to attend Lead Gen World, make sure to register by Friday or by the end of day Friday. So you could at least save a couple $100. And don't forget, we have a no hassle return, refund policy if you let us know outside of 14 days to the event. So sign up now, save some money. If for some reason things change, just let us know prior to 14 days to the event, and we'll give you a full refund. So there's no need to wait till the last minute and waste money. So I see everybody saying hello. Good. Welcome, welcome, welcome. Let me introduce the man, the myth, the legend, the czar of TCPA world. Yes, you, Eric Troutman from the Troutman firm. Eric, I really appreciate you doing this because last week I got your email that, the number one topic we're going to maybe first kick off with was the CFPB was dead. And I said, so I of course had to open up tcpaworld.com, read the article and go through it. And then following that, I think a day later, you broke another article around the TCPA class action, their ability to apply damages. And so these are two really, really major things. And I called you up. I said, listen, let's get on a live broadcast. Let's do it live. Let's do it live as what was the guy from Fox News said? Anyways, let's get on live and talk about this and see if we can share some of this information. You said, heck yeah, let's do it. And I appreciate your willingness to sort of jump in the pool head first on this sort of stuff and go live and talk about it. So thank you for joining me today, Eric. Let's just dive in. Which topic do you want to sort of cover first?
All right. So first, let me just say, Lead Generation World, sign up. I know a lot of you folks just went to a conference and there was no czar and there's a lot of sad faces and people were saying like it wasn't the same. I get it. Guess what? The czar will be at Lead Generation World for a full hour segment. It's going to be so good. We're going to talk about everything that's new and upcoming in a compliance perspective for everyone in the Lead Gen world. You kind of got to be there. Okay. So I encourage you to sign up. Let's talk first about Community Financial Services Society of America, the big CFPB ruling out of the Fifth Circuit Court of Appeal. Fantastic, amazing, incredible ruling. Hopefully everyone read the article, but let me break this down. The CFPB, all right, hopefully you all know that is the Consumer Financial Protection Bureau. That is the federal government's #1 watchdog when it comes to consumers, particularly, although not exclusively, in the financial services, mortgage banking sector. All right, so if anyone's listening to me is involved in the banking sector, you know who the CFPB is. They're very aggressive, one of the most aggressive agencies. And they're constantly doing audits, they're constantly doing exams, they're all over people in this industry. I'm not saying it's good, I'm not saying it's bad, I'm just saying it's a fact, right? Very powerful organization. The Fifth Circuit has held that CFPB is essentially a dead organization, that the organization has received funding in a way that is not constitutional. And because of that, nothing that the organization has done from the beginning in 2011 until today, for 11 years, nothing that the organization has done has been legal. It has been operating completely illegally and it has no power. Now, this is just one court, the Fifth Circuit Court of Appeal, that's got the word appeal in it. So you know it's a powerful court. It's not like a small baby district court. It's a powerful appellate court. It's not the Supreme Court, though. Okay, so it's just one court. There are 11 circuits in this country. You may or may not know that. This is the Fifth Circuit. It's the circuit where Texas is. Maybe you're not surprised by that. Where Texas and Louisiana and Mississippi. Okay, so within that geographic footprint, the CFPB is essentially dead. But truthfully, it's probably dead across the country. And here's why. The Fifth Circuit's ruling is actually correct. And to understand why, you have to know something about two books that are back here. They've always been back here. You guys have probably never noticed them before. The Constitution, right here. I'm a big Constitution guy. I think you guys know that. And the Federalist Papers. I'm not sure if you folks ever read the Federalist Papers, but you should. Now, I'm a guy, I think you know this. I went to Berkeley, right there. There's this side, Oski the Bear. I'm a Cal guy. When I was at Cal, I studied politics. And in particular, I studied political theory. Huge fan of political theory. And most of you learned this in like 7th, 8th, 9th, 10th grade. But our country is at least theoretically, right, based on the idea of checks and balances between three different branches of government. I think we've all learned this, right, at least in theory. Now, the political parties in this country have screwed everything up, and there's no checks and balances anymore, because if one party takes control of everything, then they just do whatever they want. It doesn't matter what everybody else in the country wants. It's just what they want, right? And that's true of the Democrats and the Republicans. It's just political parties are unconstitutional, but leave that alone. The way it's supposed to work is that Congress is supposed to have certain powers, the president is supposed to have certain powers, and the judges are supposed to have certain powers, and they're never supposed to mingle, they're never supposed to meet, they're supposed to jealously guard their powers and not ever let any of the other branches use their powers. Now, the CFPB is technically part of the executive branch. It's technically part of the president's powers, okay, technically. The Congress, of course, it has the power to create law, and it also has what's called the power of the purse. That is the power to spend money. You folks may or may not know this, but anytime the federal government spends any money, even $1, Congress has to actually pass a law to allow that to happen, which is why sometimes you've heard the government shuts down, right? Oh, the government's shutting down. You might wonder, why is the government shutting down? It's because the Congress, right, usually political parties in Congress are bickering with each other, and they've decided not to pass that law that day. Okay, and because the law didn't get passed, now the government has no money, and the government has to shut down. It's very similar to what happened back in 2011. You might remember when we got downgraded as a country. Remember that? We were downgraded by a sovereign ranking organization. That's because Congress decided they weren't going to pass a law that was necessary to raise the debt ceiling to allow additional funding to take place to fund the national debt. Again, all of that is kind of window dressing, but it's important to understand that Congress has a very specific power, the power of the purse, that no other branches, neither the executive nor the justices, the judges, are allowed to use. If they do, it's unconstitutional. The CFPB was given power by Congress to receive funding in a way that was very different, right? Again, normally any other agency, in order for them to have funding, Congress has to pass a law. They have to literally pass something called an appropriations bill, which says we're going to allow the FCC, the FTC, the DOJ, whoever, to have money this year, right? The CFPB was sheltered from that. The Congress was not allowed to give them money. They didn't have to pass a bill. The CFPB had the ability to get money directly from the Fed, from the Treasury, where the banks and the finance companies that the CFPB actually oversaw, they have to pay money into the Fed, right? That's just something that they have to do. The big money many-center banks, they have to pay money into the Fed. And essentially the CFPB was self-funded by the organizations that it was overseeing. Congress thought this was fine, right? CFPB is not getting money from taxpayers necessarily. It's getting money from the banks that it was overseeing. And so this felt like it was okay. But the Fifth Circuit said, no. Absolutely not. This is unconstitutional. You're breaking the separation of powers doctrine because you're taking the power of the purse, you're taking it away from Congress where it belongs, and you're giving it to an executive branch organization, the CFPB, and you cannot do that. So essentially what the court found was that the CFPB's entire funding from the day it was created back in 2011 until 2022 was invalid. And so the specific issue in front of it was something called the payday lending rule, which many of you folks listening to this probably know what that is. It's a very shall we say, aggressive rule the CFPB came up to, presumably to protect consumers, but really it put shackles, like not just handcuffs, like shackles on the payday lending industry. And the payday lending industry was pushing back. And the Fifth Circuit found the payday lending rule is invalid. It's unconstitutional. It doesn't exist. Not because the CFPB lacked the power or did anything wrong when it passed the rule, but because the funding, the life's blood of the CFPB was unconstitutionally provided from the start. So not just the payday lending rule, but especially the payday lending rule, but everything else the CFPB has ever done is unconstitutional and invalid. So any of you that are, regulated banks or finance companies, that's a pretty big deal. Like your primary regulator, other than of course the OCC, just got like completely annihilated. And again, that's only in the Fifth Circuit, but I'm going to tell you, I think the Fifth Circuit is correct. And so now what happens, right? Well, now Congress is presumably going to fix this. It's an easy fix, right? All Congress has to do is say, okay, never mind. CFPB funding is now part of our appropriations bill. When we pass our next appropriations bill, the CFPB gets funding. And just like all the other agencies, it's alive again. But until that happens, it's dead. The CFPB is dead. Really very fascinating. Now look, if you are a regulated organization, I am not encouraging you to say, oh, we can do whatever we want now. Let's just go crazy and harass consumers. And what's redlining? Let's throw all this out the window and we'll just target certain segments of the population. No, I would not encourage you to do any of those things. However, if you are facing any kind of action and you're wondering whether or not the CFPB has acted appropriately with regard to you, or there's any kind of tweener issues, or there's anything where there's a gray area, and you're thinking, is now a decent time to try to flex on an organization that's been very wounded? The answer may actually be some form of maybe, which normally you would never say that, but it's a very interesting moment in time. So if there's anything that has happened in the last 4 to 5 years that affects your organization that you want to challenge that the CFPB has done, there's a window, right? There's a window, and it's definitely something to think about. So that's big news, obviously. I'm happy to answer any questions if you folks have them, but it's a really, really big change. It's a big shift, like when anytime there's a huge shift in the law, and this is huge. I mean, literally, like this is, think of Antarctica and the giant mile-wide iceberg just broke off into the sea. Like it's huge what just happened. Everyone's just kind of standing around thinking, okay, well, what does that mean for me? And there's going to be, it's very specific, what it means for you. So if you've got questions, you should call me. But you should just keep in mind, big shift, really big shift. And again, I think the Fifth Circuit got it right. So that's number one, Mike. Go ahead.
Okay, so just a couple questions along those on this topic. What is the foreseeable future? How does this play out, and what's that timeline look like to you?
Yeah, so it's very, very interesting because I don't think anyone in Congress really expected this to happen either, right? No one has been talking about, oh, the CFPB is illegal, right? Like neither party has been saying that. Biden hasn't been saying that. Like no one's talking about that because no one saw it coming. I didn't see it coming, right? I mean, it's the right ruling, but no one saw this coming. So it's very interesting. Like anything else in this country that requires Congress to do something, it's politics. Right. And so if one party or the other party, again, I hate political parties. I hate both political parties. So I'm not in any way trying to blame one or the other. I'm blaming both for everything. They're always to blame. So if one political party or the other decides it's in their best interest to not fund the CFPB, it is conceivable that this organization stays dead for some period of time. Now, I find that hard to believe because I don't think anyone on either side thinks it's a good idea to not have any oversight over banks and finance companies. I just feel like that's probably not in anyone's best interest. So I would anticipate that both sides will work together in some sort of bipartisan fashion to do something on this issue. But I will say there's already been a lot of discussion of, Paul Ryan is talking about not raising the debt ceiling, right? Which is, you guys should understand that's code for we're going to shut down the government again, and or we're going to possibly not pay our national debt again, which is, again, something that can lead to very treacherous circumstances on the market. But, if that's already kind of the narrative, you can imagine that passing a basic appropriations bill that would fund something like the CFPB, it should be automatic, but maybe it won't be automatic. So, from my perspective, this is something that should get fixed. If it wasn't for the fact that we've got an election in like 3 weeks, and so nobody in Congress is working because they're all out there pandering to you to have you vote for them when they should be working, in my opinion, but they're not. Like, none of them are working, right? None of them are working right now. They should be. If they were, they would pass this bill, right? Very simple. Like, honestly, I could write it in 10 minutes and they could pass it in 20. I mean, and CFPB is alive again. But again, that's just not the way our country works, right?
Yeah.
And so it's going to be at least December before the CFPB has blood again. And honestly, again, depending on if one side or the other thinks it's in their best interest, you know, it could be months or it could even be years. But I mean, I don't know. I don't think it'll take that long.
Does it matter if any of the other circuits make the same ruling, or is it really just this circuit was enough for it to be addressed by Congress?
This circuit is enough because they're right. You know, that's the issue. They're correct. And so it will take a year in all likelihood. I mean, I guess there could be some, you know, extraordinary appeals, but it'll take a year before any other circuit gets to it. I predict that Congress will have fixed it before any other circuit gets to it. The other circuit will get to it and say, oh yeah, the Fifth Circuit was right. But by then it doesn't matter because it's been fixed, right? That's most likely to happen. I would imagine the CFPB is probably going to do something dumb, like try to do an appeal to the en banc Fifth Circuit, which they will lose. And then they might even do something super dumb, like try to take it to the Supreme Court, which this Supreme Court, they will definitely lose. So I don't think they're going to do that. I think they're going to lay down, they're going to leave well enough or bad enough alone, and just work to get the funding that they need through Congress, which is that's the right thing to do anyway. I mean, this like special back room, you know, deal to get the funding through this weird like perpetual motion machine that they had set up. I mean, it really is unconstitutional. There's a constitutional provision called the appropriations provision in the Constitution that provides that Congress must pass laws to fund government activity. So, I mean, it's just plainly unconstitutional. So
yeah. But in any case, it looks like rocky roads for the CFPB for the foreseeable future, especially if Congress is playing politics on funding it every 4 years or whatever it may be. Okay. Again, just a reminder to those listening in on LinkedIn or YouTube, feel free to use the comments to say what's up or ask questions. We will see them and we can address your questions. And so let's move on. The next item, which you released, I think it was it a Friday maybe last week, with regards to the Ninth Circuit. Tell us about that. What happened?
Well, so there's two developments out of the Ninth Circuit recently, right? We've got the Visalis case and we've got the Porch case. Let's start with Visalis because it's kind of good news. Porch is really bad news. Visalis is pretty good news. All right, so those of you that don't know the backstory here, it's really kind of an interesting backstory. Visalis is a multi-level marketing company. I think they've got, you know, they sell like, I don't know, wellness products or something. And they got hammered, I mean, destroyed by a jury in Oregon back a couple of years ago, 2019, I want to say, for $925 million in a TCPA case. Yes, you know, for people that wonder, is the TCPA important to your life? Yes. Okay. A $925 million judgment was entered against a company for violating the TCPA. Pretty important statute that you guys should be aware of. A couple of really interesting wrinkles with the case, like really interesting. Visalis actually had consent to make the calls. They actually had written consent to make the calls, but the written consent was not sufficiently conspicuous and did not contain the Troutman 9, right? That the that the FCC requires as part of the CFR requirements. Hopefully everyone listening to this knows there are 9 things your disclosure has to have. And if it doesn't have them, then something really bad can happen, like what happened to Visalis. So Visalis made these phone calls with consent, understand, just not with the right level of consent. And so they had a $925 million judgment entered in against them as a result. It gets even weirder. So the Visalis actually went to the FCC and asked for a retroactive waiver of the Troutman 9 requirements in their case because they had written consent. They just didn't have all the 9 requirements that the CFR requirement. And so they asked the FCC for mercy. And the FCC, this is crazy. This is crazy. Like 2 days after the judgment was entered against Visalis, the FCC actually entered a ruling saying, "We bless you, Visalis. Your sins are forgiven." And they gave Visalis the waiver. You're going to love what happens next. Vaisalas's lawyers go running into court and they say, Judge, we got this waiver from the FCC. We've been absolved of all of our sins. So we don't owe $925 million anymore. And the judge looks at this and goes, well, you know, I appreciate this, but you didn't raise the defense of an FCC waiver during the case at all. So because you never told me or the other side about what you did with the FCC, I'm going to find that you have waived your waiver argument. And so Vaisalas went from owing $925 million to owing $0 to owing $925 million again. Okay. So they appeal. They appeal to the Ninth Circuit Court of Appeal. And they raise a bunch of arguments to the Ninth Circuit, and they lose on basically everything. They lose on a bunch of standing arguments. They lose again on this waiver argument. The court found, yeah, you did waive it. You should have raised the fact that you were going to the FCC for a waiver, and you didn't do it. Really big mistake, by the way, but leave that alone. They lost on everything. They were dead. And then 6 Mexican workers saves Vaisalas. And that's a strange thing to say, but there's a case. It's actually called 6 Mexican Workers. That's the name of the case. And the case is actually, it's about 20 years old. And it's a very obscure case. It's outside of the context of the TCPA. It has nothing to do with the TCPA, but it looks at the concept of aggregated damages. And when aggregated damages can be so high that they actually become unconstitutional. And in the 6 Mexican Workers case, there was a 7-part test that was set down by the Ninth Circuit Court of Appeals that informs a court, essentially, is the harm that was caused by the misconduct more or less on the same level as the aggregated damage provision or not? And again, there's 7 factors. You know, it's a little bit nuanced, but ultimately what you're looking at, does the penalty match the crime, right? So here we've got Vaisalas owing $925 million for calls that were, again, made with consent, just not the right level of consent, that the FCC eventually forgave, but that their lawyers frankly screwed up and didn't raise. So in this context, is it really fair to say that Vaisalas should pay $925 million, or should it be reduced to some degree? Now, the Ninth Circuit did not answer that question. The Ninth Circuit said, okay, district court, it's your job, district court, to weigh these 7 factors now, the 6 Mexican Workers test, and determine whether or not the amount of the judgment should be reduced. Now, I'll tell you, Vaisalas previously asked the same court to reduce damages, not using 6 Mexican Workers test, using a different test, and the same court already said, nah, the penalty fits the crime. I'm not reducing this. Y'all knew what you were doing, and you violated the law, so you're going to pay. So, you know, whether or not Vaisalas is going to get bailed out here when it goes back in front of the same judge, although on a different standard. So maybe there would be a different result here. You know, that remains to be seen. It's possible that Vaisalas is still going to be crushed for $925 million. It's possible that it gets reduced to some degree. You might remember the Dish Network case from a few years back, where the original damage provision was like $1.6 billion, and they reduced it down to like $256 million. No, that's too high. It was $156 million. That was the Central District of Illinois. So there is precedent in the Golan case as well versus Veritas, where that was $2 billion judgment was reduced down to, I think, like 80 million. So there's precedent, right, for reducing these damages down. It doesn't happen all the time. But now in the Ninth Circuit, again, there's going to be another opportunity for Vaisalas to reduce that damage. Maybe it comes down to something like 80 or 90 million, a mere 80 or 90 million. You know, who knows? We'll have to wait to see. But for everybody else, right, it's important to keep in mind now that aggregated damage provisions might be unconstitutional. This is critical. In the Ninth Circuit, the district courts have over and over again held, no, there is no protection against the aggregated damages of the TCPA. Because Congress made a decision, and that decision is consistent with constitutional principles. But for the first time now, the Ninth Circuit has said, no, that's not true, at least not where you add up all the damages. So if you are sued in an individual suit where someone wants $500 per and they receive like 25 calls, you can't come in and say that's unconstitutional, right? That's not what the Ninth Circuit says. What the Ninth Circuit is looking at is the aggregation in a class action of damages, that it gets so high that essentially it becomes a death sentence for the company. And that's really important, right, for 2 reasons. One, obviously, if you're in that situation where you've got $100 million judgment against you or more, now you've got yourself an argument. Obviously, none of you want to be in that situation, right? I mean, this is like you've got paddles, right, in the emergency room. Nobody wants to go flatline just to see if the paddles are going to work, okay? But at least, there are now a set of paddles in the emergency room that you didn't have before. So if you do end up flatlining on the table, they can bring you back to life using this argument. But again, you don't want to go there. Secondly, and frankly, I think more practically, more importantly, for any class action litigators that are out there, to me, this is a new arrow in my bag of tricks when I am going to be opposing certification. And it weighs to me on the superiority prong, where essentially I can tell the judge, listen, judge, for all the other reasons you shouldn't certify the case, but for one additional reason, if they certify the case, the class actually can't even receive the damages that the plaintiff is seeking because it would be unconstitutional under the 6 Mexican workers test. So it's not a superior way to litigate the claims of individual class members. Instead, they should get to bring their own individual suits so that their individual claim for damages is not going to be reduced, right? That's what the Ninth Circuit says. Individual claims for damages are not reduced. Only aggregated claims for damages are. So, I mean, that's a pretty big factor, right? If I'm a district court, I'm going to be thinking about that. Why would I deprive people who are harmed of their full right to recovery when I can allow them to bring their own suit instead of forcing them all to do it in a form where they're going to get less money? If you think about it, that doesn't make much sense, right? So I think this is a really good ruling, again, not just for companies that are facing catastrophic damages. Hopefully, that never happens to you, but also even for companies that are just facing a certification effort in a case that might lead to catastrophic damages. It really is, I think, a really nice feather in the cap. So big news.
So, so thanks, Eric. So, is it is there a determination of what value, or is so much more than it exceeds what's legitimate, for a class action? I mean, what is the determination of it being sort of unconstitutional potentially or not?
Yeah, so there's no bright line test. You may know that there's a case called BMW that was decided by the U.S. Supreme Court that said in the punitive damage context, outside of very limited circumstances, there's like a 10-to-1 presumptive limit, right? So if you cause $1 in harm, presumptively, you can only get hit for an additional $10 worth of punitive damages. Otherwise, what you're doing is illegal, unconstitutional. The Ninth Circuit refused to apply the BMW test, which is under a different rubric here at the aggregated damages perspective, because aggregated damages are not punitive damages. Understand, these are set by Congress, not set by a jury. So it's a little bit different. And the Ninth Circuit was very clear, like we're not applying a 10-to-1 limit. We're not going to do that. It's not apples to orange, apples to apples. We're not going to apply that rule here. But again, the 6 Mexican workers test gives you that 7 criteria, and it's very fuzzy, Mike. Like it's in the eye of the beholder, and that's what I'm saying. Like, I mean, you guys all know this. The federal judges in this country are very powerful. These are very powerful individuals in a lot of ways. And here's yet another way that they're very powerful. They essentially can look at these 7 factors and weigh them however it is that they want to weigh them. And again, the factors include things like how much harm was actually caused. Did the defendant really know that what they were doing was wrong, right? And there's 7 of these things. And ultimately, though, it comes down to like what you would consider to just be culpability and fault, right? How badly did you screw up? And, what did you do to prevent screwing up? And how big of a damage to society are you? Like, how big of a menace to society are you, right? That's kind of the way this goes. So you have to imagine if you're a federal judge and you've got this company in front of you that's been litigating for the last 3.5 years, that you've already gone to jury trial with, that you've already said, on more than one occasion, I'm not reducing the damages. I'm not giving you a new trial. I'm not decertifying the case. I'm not going to honor your waiver request. This judge is probably not a judge that's going to look at this and say, oh, okay, maybe only, $50 million. I think that, the judge is probably going to reduce it some, because the Ninth Circuit has essentially suggested that that the judge should. But I mean, I don't think that Visalis is going to walk away from this for less than $100 million. But again, it's all in the eye of the beholder, right? This judge could say, "Nah, I'm going to keep $925 million because I think all the factors weigh against Visalis." The judge could, if it wanted to, say, "You know what? Here, I think there's only 10 cents worth of harm total." Right? Like, that's what I'm saying. Like, there's tremendous power now in the hands of these judges, which is a good news, bad news situation, as you can imagine. If you're already facing $900 million in damages, I mean, can't get worse. But you can imagine situations where the judge is in a position to suggest that. I mean, I don't think they can go above the $500 limit, but certainly saying I'm not reducing this $1. Like you earn this, and you made your bed, you're gonna lay in it.
Okay, so real precisely, what part was deemed unconstitutional?
None of it and all of it, right? So the TCPA as it stands is not unconstitutional at all, right?
Yeah.
Currently as it stands and as applied to any individual claimant, not unconstitutional. What was deemed unconstitutional, again, looking at 7 factors, is all of it, aggregating all of the claims of class members together in a single case that results in $900 million in damages, again, against a company that maybe didn't do that much harm to begin with. So it's the process that was found essentially to be unconstitutional. The process of aggregating damages across an entire class in a way that gets inconsistent with due process principles. That is what is unconstitutional. The TCPA itself is not unconstitutional.
Okay. Yes, I got that. Okay, perfect. For all those listening, are probably wondering if you know the answer. What was the few items that they did miss, Visalis miss on getting consent? They said you said they got most of them, but they missed them. Do you know what they missed?
Yeah. So remember, under the CFR, right, 47 CFR 64-1200, what is it now? F15 is the express written consent rule. You've got a bunch of ticky-tack things that you have to include. Off the top of my head, I don't believe that they mentioned automation, and I don't believe they mentioned marketing, right? So it was by filling out this form, you're going to receive calls from Visalis regarding whatever, but they didn't mention it was marketing, and they didn't say these were going to be automated calls or pre-recorded calls, right? And under the rules, you have to mention those things. And because they didn't, they got hammered.
That's a scary one, because I was just reading a disclaimer yesterday on a page, and it didn't have that either. And I'm sure a lot of companies don't.
Well,
little things, just one word here, one word there.
I just reported today on TCPA World on a case. Same thing. Under the FTSA, a for-profit college was communicating with individuals who had opted in. But their opt-in didn't mention promotion, didn't mention marketing. It did mention automated calling. It didn't mention pre-recorded calling or text messaging. It was a text message case. The court said invalid consent, right? Like I preach this all the time. The Troutman 9. Like, you have to have these things. They're not optional. They're just not. I mean, people want them to be optional, but they're not.
Yeah.
Just ask Visalis. All
right. Good. Let's move on to the third.
Yeah. So the third case is, actually probably the worst of the developments, but it definitely is the worst of developments. It's a case of Chanette versus Porch. This Porch case is a really interesting backstory. That the CEO of Porch is actually personally named in the case. A number of these suits. So the backstory here is Porch is a company that provides leads for consumer goods services, right? Home improvement services, let's say, lawnmowers, folks that are gardeners, folks that paint houses, folks that do solar, stuff around the house, right? And they have a bunch of leads for consumers, right, that want this product. They have a website. Consumers go onto the website. They say, I need a contractor to come give me a new kitchen sink, to come, fix my dishwasher, whatever it is, And so in order to provide this service, Porch has to have a big network of service providers who can give the consumers what they're coming to the website to get, right? So what Porch did in order to build its network is it would go on to thousands, I think even millions of on websites that have listings for these service providers, right? I mean, obviously, think of Google, but you can think of Yelp, Yellow Pages, White Pages, whatever, like all the different places where people would list their numbers. And what Porch would do is it would basically just scrape all those phone numbers that belong to these service providers, and it would just start calling them, right? Now it's disputed as to whether or not these calls were made manually or they were made using automated technology. But the assumption was, for purposes of this case, that these were done manually. There was text messaging, right? Manual text messaging, and so Porch actually won at the district court level, arguing that businesses are essentially not protected under the TCPA, which is just bonkers. That's just not true. Okay, they had no chance of winning that. They won it. The district court in Idaho, just like, I don't know what the judge was doing that day, just wasn't paying attention. It happens. People make mistakes. So rather than just like leave well enough alone and just like settle the case, they decided to take it on appeal and make this argument to the Ninth Circuit. They had 0% chance of winning that case, and they lost. I mean, it's not a surprise. They lost. But, you know, losing that argument is one thing. But as we go through the ruling, you'll see there was a cascade of losses, and some of these are really bad. So, you know, the first loss, as I just mentioned, is yes, the TCPA applies to business cell phones. Okay. So if you've got a cell phone and you're trying to text somebody for B2B purposes, understand that the TCPA does apply to those calls if you're using automated technology. And as the court found, there is a presumption that if the phone number is on the DNC list, it is residential. So it does not matter if you are trying to call for a business purpose. It does not matter necessarily if the business is holding out that number as a business number, right? Like my phone number. My phone number is my business number. It's also my residential number. It's my only phone, right? I use it for both purposes. The court found that if the phone number is on the DNC, presumptively, it is residential. And the defendant has to prove that the phone number was actually used either solely or to such a degree for business purposes that it could not be viewed as a residential number, which, as you can imagine, is a very tough standard. And by the way, very unfair, considering that the plaintiff has the burden of proof on every element of their claim. So the plaintiff should have to prove that this is, in fact, a residential number, not vice versa. But because of the context in which Porch raised this argument, the court just really hammered them and found this presumption existed. The court also found, unsurprisingly, that merely by listing your phone number online, that does not amount to consent. Now, that shouldn't be a surprise to anybody, because on the one hand, in order to make marketing calls, which these would be, you have to have express written consent. And plainly, this is not written consent. But even if you required just lower express consent, the court said providing a number online is consent for consumers to call you, right? If you're Bob's house painter and you put your number up on the internet and a consumer calls you and says, hey, I want to talk to Bob's house painter about getting my house painted, sure, that's consent. But it's not consent for service providers to call you and say, hey, Bob's house painter, would you like to sign up and be part of our network and receive leads from consumers in exchange for paying us money, right? That is the offer of a good or service into the stream of commerce, right? Through a marketing effort via the phone. It's classic telephone solicitation. And the court, as I said, was not going to imply any form of consent there. So if any of you are thinking, and I've heard this from time to time over the years, well, you know, Eric, they put their number out there publicly, so why can't we call it? Well, the Chenette case tells you why you can't call it, because that's not consent, right? It's consent only for the narrow purpose for which that consumer or that business might have put their number up there, again, to receive calls from consumers. Okay, so that's some of the bad news. Here comes the worst news of all. And this is very nuanced. Not everyone caught this. In fact, I'd imagine, you know, maybe 1 in 10 lawyers even caught on to this. But it's very important. All right. How many of you out there are dealing with litigators that are setting up lawsuits on your website? Everybody's hands in the air. I know I can't see any of you, but I know all of you are raising your hand right now. So I think you folks all know this by now. You know, one of the reasons the Czar is so famous is because I had the Stoops case, right? And this was, my client was Wells Fargo. Melody Stoops was the lady who had 86 cell phones. You might remember the story here. And she was intentionally getting cell phones from the Florida area code, looking for wrong number calls to the previous users of those cell phones. And then she'd collect a bunch of them, you know, make meticulous notes of all the calls that she received. And then she would sue companies when she got over 100 calls, right? So my client, right, they fell right into the trap. They were trying to reach a customer that was, you know, behind on their debts, had no idea that the number had changed hands. Apparently it had. Melody Stoops had the phone number. She sued my client. You know, she wanted some amount of money. You know, the client obviously could have settled the case, but they didn't. Instead, they paid me more money to fight it and to set good precedent. And we did. And we won the first ever ruling dismissing a TCPA case on Article 3 grounds, and also incredibly important on prudential standing grounds. And that's important because when prudential standing is the basis, that judgment is with prejudice. It can't be filed anywhere else ever again. The case is dead for all time. Okay, so prudential standing limits are really, really, really super important. In Porch, they raised prudential standing arguments in this really goofy way, basically saying because everybody put their phone number out there in the internet, they lack prudential standing to sue. It's a terrible argument. It's a terrible argument. Of course, they can still sue, right? But because they made this argument in this context, the Ninth Circuit looked at this and they said, there is no prudential standing. We don't even recognize prudential standing as a thing in the Ninth Circuit, and they just threw it away. Like, one of the most important vehicles, probably the single most important vehicle that you have, the biggest weapon, the blazing sword. If you remember Voltron, we call it the blazing sword and start chopping up things. It was prudential standing, and the Porch case killed it. It's dead. Prudential standing is dead in the Ninth Circuit because of this Chenette case. It's crazy. It really makes my blood boil because it should never have happened. The argument should never have been made. The Ninth Circuit should never even had the opportunity to make that argument or to make that ruling. And of course, the Ninth Circuit shouldn't have made the ruling. It's a terrible ruling. They're just wrong. Of course, prudential standing is critically important. They got rid of it. And so now there's only two forms of standing in the Ninth Circuit. Statutory standing, and I'll tell you, under the TCPA, anybody has statutory standing. Anybody. And constitutional standing. That's Article 3. Article 3 standing is great. I mean, look, that you still can make those arguments. But again, if you win Article 3, all you're doing now is getting sued in state court instead of getting sued in federal court. So that's not the big neutralization that you want. Prudential standing was the one that really gave you the big stick. We created that law in Stoops. It was really good law. It's been followed in other jurisdictions, but not in the Ninth Circuit. It's dead now. So that's like the worst news I could possibly deliver. I mean, I know it's sad to hear that these litigators now can get away with stuff that they couldn't have gotten away with before, but that's what happens.
And they get away with it, just to be clear, by if they lose, that doesn't mean that all is lost. They can continue to harass and sue companies. That's correct?
Well, I mean, they're getting away with it in the sense that now, right, when you get sued by a litigator, Nathan Barton or whoever comes knocking on your door, they've got TCPA University, right? They set up this claim, right? In the old days, 2 weeks ago, the Ninth Circuit could say, this guy lacks prudential standing. He set up his lawsuit. He's not within the zone of interest that Congress was trying to protect. He's not trying to protect people that are setting up claims. Like, get out of here. Your case is dismissed with prejudice. You lose, right? You lose. Now, that's not available, right? The best that the judge can do now is say, I find that under Article 3 of the Constitution, you have not suffered concrete harm as a result of the conduct at issue, and I'm going to dismiss your case. But that doesn't mean that it's with prejudice or on the merits, and he can just refile that same case against that same person in state court where there is no Article 3. Now, I believe that there's some additional limitations there, but that's a different argument. So again, that prudential standing was such an important vehicle. It was really very important, and it just got taken away. And it's really very frustrating for me because I worked very hard on that Stoops ruling, right? I mean, this is like my pride and joy, and to see it just get destroyed, it just really puts a big frown on my face. Yeah.
No, these are all three really important updates, and I really appreciate you joining everyone here. I want to give at least a minute or so. We're going to be wrapping it up here, folks. And I want to give you guys a chance to ask some questions if you'd like. Just type them in the comments there if you're on LinkedIn, and we'll see it. But I'm only going to give you probably another 30 seconds to write something in. In the meantime, Eric, obviously you've got TCPAworld.com, which is exactly where I found these announcements. And I was on another call that was talking about compliance, and they were giving updates, and this didn't come up. So TCPA World is, arguably the source for getting real updates on real items that can affect companies within all industries, but more specifically our own sort of performance marketing industry. So for those that are not subscribed or not aware of TCPAworld.com, you need to go check it out and subscribe. It's definitely worth it, which is free. So
which is free, with nothing. So there you go.
So, ton of value from it. While we're waiting here, just a couple minutes, another 30 seconds. Anything we need to know about what you're up to in the coming future outside of lead generation world you're going to be at? in January in San Diego, which can't wait to have you and your colleague Pooja also participating in the show. Anything else happening?
Yeah, we've got a lot going on. Big announcement on Monday, but I guess I'll break it now for those that are paying attention. We're opening our Florida office down in Miami starting Monday. So you're going to love to hear about that. I'll be speaking of Florida, at the big TCPA summit. Mike, you should get down there sometime. Sponsored by DNC.com. It's a 2-day event focused almost exclusively on TCPA and privacy issues regarding outreach telecom. It's attended by, all the top companies that really care about compliance are there. The aggregators are there, carriers are there. What's that?
Do you know the dates offhand and the location?
Yeah. It's December 5th and 6th down there in St. Pete's, and it's fantastic. I'll be there. A few other lawyers will be there. Pooja will be there. Our newest addition from Florida, who I'm not going to name yet, will be there. That'll be great. And then we just launched Reach. I don't want to spend a bunch of time talking about Reach just yet, but officially the bylaws are complete. The articles of incorporation were filed yesterday. So responsible enterprises against consumer harassment is now a reality. We'll have standards set. There'll be a seal of approval. Membership will be available to all. Board membership will be available to only 30 wonderful hand-chosen individuals from great companies that are lead buyers and those that service lead buyers. Everybody that is committed to stopping unwanted robocalls to individuals who did not ask for them, cutting down on lead fraud, creating real standards so that consumers know exactly what they're getting when they sign up for a disclosure. If this sounds like something that you're committed to, give me a call, because it's a reality. And I'll tell you, the folks that join are going to receive the benefit of regulators and those in commerce understanding that they take, TCPA and very seriously, and stopping unwanted calls very seriously. And those that elect not to, they're sending a message too. So I'm sure that there'll be a lot of folks signing up, I would imagine.
Yeah, absolutely. I'm looking forward to hearing more information about that for sure. So I guess we'll leave it there, Eric. I really appreciate you, like I said, picking up the phone and going, yep, I'll do it, and getting on and talking about these 3 important things. And maybe as things come up, we'll have to do it again. So I appreciate you and everybody else that participated and listened in. But we'll end it here and catch up later.
Yep. All right, man. Thank you so much. Bye, everybody.
Bye, everybody.